Good morning, everybody, and welcome to the First District Court of Appeals. We have two cases to be argued this morning. When I state your case, if the parties or the attorneys could please state your name and who you're representing and your readiness to proceed, please. The first case is C-23-0462, in re Guardianship of James Dwyer. Okay, thank you.
I'm Barry Fackel on behalf of the police.
Okay, thank you.
Thank you.
And our second case is Ho v. Coe, and that's C-23-0571 and 645.
Ross Evans, on behalf of myself.
Thank you.
Good morning, Your Honors. Dr. Tachapal, appellate.
Thank you. Okay. I will be keeping your time. When you see there's a green light, that means that you're good. The yellow light means that you have about a minute left, and the red light means that your time has expired. Ms. Dwyer, would you like to reserve any time for rebuttal? And what that is, basically, you can respond to, you can reserve a couple of minutes of your 15 minutes to respond to what your opposing party says.
5 minutes, please.
Okay. You may come up, and whenever you're ready, we can get started.
Good morning.
Good morning.
Thank you for taking my case. I'd like to say, first off, that I come before you humbly as pro se. I have been in litigation for the past 5 years. I appreciate the hard work that lawyers do, attorneys. I also have gotten to the point where the litigation has to stop, and this case I thought was pretty straightforward. It was difficult financially to continue anymore with the fees, but I believe that the court will see that I have done nothing wrong. I would like to start out by mentioning, as I did in my brief, that this is the 80th anniversary of, D-Day. And I mentioned in my brief that my father fought in World War II. And I said that because we live in a very self-absorbed world today. And then that generation taught me a lot. And we didn't have a lot of money growing up, and I put myself through school and earned my doctorate. And so I appreciate all of their hard work and good example to help me be the citizen to give back to society as a nurse practitioner and caring for sick babies with HIV disease all the way to the present with people with mental health disorders. I don't earn a lot of money, and right now I'm not working because I finally reached that point, but I hope to go back. But so my parents in 2003 set up trust fund for Jimmy. My point in saying that my dad fought in World War II is that he fought for our rights as Americans. So you can sit here and judge me whether or not I'm abiding by the law and being a good citizen and steward of Jimmy's money, James Dwyer. And I uphold that. And I want to continue with my work as a trustee. I want to start out by saying in 2003, Mom and Dad created the Community Management Fund, which is a Medicaid payback pool trust. So I'm sure you understand what that means. I can answer if you don't, would like further explanation.
Well, Ms. Dwyer, I appreciate your arguments, but I guess to focus on like the issues before us on the appeal, there was a settlement agreement in 2021, right? And then there was the finding that you had breached that settlement agreement, which is, I thought, what was the basis for part of your appeal?
Well, they consolidated it. Because the judge removed me as the trustee for the Special Needs Trust. And so I don't understand why she did that, because Mom and Dad had established the trust, and then in the community fund, there are lines where places where you can put a successor trustee. They could have listed any of the siblings, and they didn't do that. They just put myself down as the trustee of the trust. And there was no exploitation of the funds, no stealing, no withholding of financial requests for reimbursement. They were given everything I had receipts for, because I'm responsible for all of that to the state. And there was no commingling of any of the funds. The Special Needs Trust was a separate trust established by Mom for Jimmy's needs that the Medicaid, the SSI, doesn't cover. Again, I did not do any fraudulent behavior, not take any money from Jimmy. And then the Universal Trust Code, the Ohio Revised Code 5807.06, it said it is more difficult to remove a trustee by the settlor. The settler's confidence in the judgment of that particular person whom the settler selected to act as trustee is entitled to considerable weight. And the judge dismissed me in their trial when Suzanne became the guardian, saying it doesn't, quote, it's in the docket, makes sense because Suzanne's the guardian. But my argument is nowhere does it say in the law that the guardian should be the trustee. And so you can wear different hats in the role of taking care of a person with a disability within the family. And so I'm pleading that I remain as trustee of Jimmy's Trust Fund, Community Fund, and Special Needs Trust. And then the second thing was the having me pay all the attorney fees. The agreement and the settlement was for 6 months as a trial period. In 3 months' time, the co-guardian was 6 months for co-guardianship, because up till then I have been the guardian. And Suzanne requested a trial to remove me as guardian. And she requested financial statements. She got the 3 years' worth of the statements. This is the second time she requested them. I had to give them again. They got all of the financial statements. And so now they are claiming that I should pay all of the attorney fees, which is comes to close to $60,000.
Dr. Dwyer, have those already been paid, though?
Yeah, I paid them.
Okay, thank you.
I'm just asking for reimbursement. I guess that's the right word for attorney.
Well, but the fees were assessed because of the fee shifting provision.
Of the what?
The fee shifting provision, it's a provision in the settlement agreement that says if someone breaches this, they're responsible for the attorney's fees. And the court found that you had breached this agreement, which is why it imposed the attorney's fees. Is there a basis why you think the court was wrong there?
Yes, because they are having me pay for all of the trial fees, all of the preparation, all of the work that went into removing me as guardian. That was not part of the settlement. The settlement was for Suzanne and I to work together for 6 months. And there's many, many parts of the settlement that they broke, but I considered it to be like a learning curve that we learned to work together. It never occurred to me to bring her to court and say, you're breaking the settlement by not letting me go to doctor's appointments, blah, blah, blah. And so I was shocked when she moved, just because she hadn't received the statements, which she did. And I had offered to bring them to her personally, because that's a lot of statements go through the mail, but she said it's too late. So I think that the judge erred in her decision, because the whole trial was about removing me as guardian, and it was not about the settlement.
Ms. Dwyer, this is a very technical question, and I realize that you may not have known to do this, but did you make a request of the court below to stay your payment of the attorney fees or to postpone paying them while this appeal was going on?
I had to go down. They garnished them. So I had to go to the Court of Common Pleas. And they said that since it was under appeal, they had to wait so much time. It was about a month or so. This is last year. And then when I went back, the Court of Common Pleas awarded the fees.
And did you make any request in that proceeding for a stay or to stop?
I didn't know you could do that.
Okay, thank you.
I didn't know that you could do that. So, that I think is pretty straightforward, that I want, a desire to honor my parents' wishes, and they've created a trust. They went before a lawyer 13 years ago, before their death, and decided to put me in charge of the trust fund and to have all of the trust fund money, and to have a judge just dismiss it and say it doesn't make sense. It is her words that it should be Suzanne. And Suzanne, is not the one out of all the siblings to be in charge of so much money. So I beg the court to understand where that I'm coming from. And again, if we were to have a 6-month trial to work together on this, and Suzanne just wanted to remove me right away, and so they proceeded with the trial. And then the whole time in the trial, all the things that we were supposed to be addressing in the settlement never came up. Only how much money Jimmy had in his trust fund in relation to the settlement. Any other questions?
Now, if you'd like to reserve your time, you have 5 minutes left. Thank you. Whenever you're ready, Mr. Fickle.
Thank you. Barry Fagel on behalf of Appalese. May it please the court. Couple things. Normally, we use last names when we refer to parties, but in this case, because we have 2 Ms. Dwyers and 2 Mr. Dwyers, I usually refer to parties by their first name. So I'm going to be, when I refer to Maureen Dwyer, I will be referring to her as Maureen, if that's okay. I don't mean that as being flip or anything like that. Just makes it easier. The second thing is, I and my firm represent Brian Dwyer, Marianne Frischner, and Suzanne Dwyer. Up until, I can't remember when, but I think it was either earlier this year or late last year, Dinsmore and Scholl was representing Suzanne Dwyer, and we took over that representation, so I'm representing all 3 of those parties now. This case, at least where we are now, it's been going on for years and years. In fact, I didn't get involved until 2022. Another attorney in my office was handling it. But in the order dated in December 2021, Suzanne and Maureen were made co-guardians of Jim Dwyer, or James Dwyer, but they call him Jim. And on page 3, as the court noted, it said on the order, if anybody violates this, and it doesn't even, it says you shall pay attorney fees for anybody breaching it. Shortly thereafter, and I call them the Dwyers, plural, my clients. The Dwyers moved to remove Maureen as the trustee because of multiple violations of the order. There was a trial held over several days that summer, and the court issued an August 2022 decision, and Maureen was represented at that time, and Maureen was removed as the guardian. And the court found 8 specific violations of the December 2021 order. And this, we've listed them in bullet points on pages 17 and 18 of my brief. But to paraphrase what the court found, and this is at the bottom of 18 of my brief, Maureen has failed to exercise due diligence in making decisions that are in the best interests of the ward, is unwilling to cooperatively perform her duties as co-guardian with Suzanne, that Maureen has failed to obey the court's order, and that Maureen has acted in a manner that is adverse, antagonistic, and hostile to the best interests of the ward. That's what the court found in the August 2022 decision. That decision was never objected to. It was never objected to. It was never appealed. It's a final decision. So the findings in that decision,
Was that by the magistrate or the probate court?
that was by the magistrate. It was by Magistrate Stargell. But those decisions, no objections were filed to them. No appeal was filed to that. So that decision legally, we submit as final. So procedurally, because the court found all the breaches of the previous agreement, my firm, I'm in Lindorse and Dryden, we filed our motion for attorney fees, and Dinsmore and Scholl also filed their motion for attorney fees based on violations of the order. The court granted it. No stay was requested.
Was there any challenge to the reasonableness of the fees, any sort of line item type challenge?
No,
or
there was
anything like that? Okay.
nothing. There were going to the merits of it, I mean, she violated the court order. There was no argument about the reasonableness of the fees. There was no argument about the rates. There was no argument, anything about it. In fact, my recollection was the argument was that Maureen's argument was she should never have been removed in the first place, but that was not the issue before the court at that point. We have since garnished her account through common pleas court. I filed notices of satisfaction of the judgment in the probate court, and I also filed a notice of my notice here in the Court of Appeals. So based on the case law as we know it, page 23 through 26 of our brief, that issue's moot. And, you know, it's a moot issue at this point. Be that as it may, even based on the merits of it, it's an abuse of discretion standard. The court found 8 specific instances where she violated court orders. And like I said, there was no objections made, no arguments made about what the rate was or the reasonableness or anything like that.
And counsel, is it your position that the order removing her from the bank accounts also incorporates the findings, the 8 specific violations?
Yes, because, so removing her from the bank accounts and stable accounts, again, it's an abuse of discretion standard. And one thing is just, she was not removed as trustee. That's actually pending before the probate court, depending on what happens here. We just wanted her removed as the bank and stable accounts. And the reason for that is, and I'm actually quoting Judge Stargell because she uses language in one of her orders, it just doesn't make sense when Suzanne is the guardian, Mary Ann is the caretaker. Jim stays with Mary Ann's husband, Selden. But Suzanne is the guardian. And as the judge says, it doesn't make sense to have Maureen in charge of all of the bank accounts when Suzanne's the guardian and when Mary Ann is the caretaker.
So is this really a best interest determination?
Yes. I was thinking, funny you brought that up because as I was getting ready last night, we used the term makes no sense, but it really is best interest. And the court really, what they found was, essentially, it was in the best interest to have Suzanne in control of, because she's the guardian, it's best interest to have his funds controlled by the guardian. And in fact, I'll even say, and we noted this on page 17 of our brief, one of the findings of the trial court, as Magistrate Stargell, one of the findings back in her August 2022 order was that, I believe this is paragraph 12, but I got this page 17. Maureen failed to fully respond to requests by Suzanne for written bank statements of Jimmy's accounts. And this is a quote now. Maureen responded that Suzanne was never going to see the bank records, and Suzanne was never going to know where Jimmy's money is. So the court had a pretty good basis, and we had, I thought, a pretty good basis for bringing the motion. The court had a pretty good basis for granting the motion based on the previous findings and based on the fact of who has guardianship. So, once again, the standard is an abuse of discretion. The trial court was in the best position to weigh the evidence of who should have control over the funds in Jim's affairs, and they found that should be Suzanne. And I submit to you, even though this isn't the standard, it is in Jim's best interest that Maureen not have control of his funds based on many things that came out there during the August 2022 order. But I'd also state that there clearly wasn't any abuse of discretion. And so that standard, I would say, hasn't even been close to being met. So we would.
So what powers does she have as trustee if she doesn't have access to the funds
Well,
and is not guardian anymore? Like, I guess I don't understand that.
well, that's an interesting question. And practically speaking, she's still in control of the funds. So realistically, here, basically what has happened is this order of she was taking her off as the custodian. The order really has no practical effect because the banks are saying, well, she's still trustee, so you need to have her removed as trustee. So that's why we went back to court to have her removed as trustee. Judge Stargill, Magistrate Stargill said, well, let's see what the Court of Appeals rules on the custodian matter. So from a practical effect, the having the order removing her as custodian still did not allow us to, I say us, my clients to get access to the funds. On the other hand, it is an important ruling at this point because I believe Magistrate Stargill, because she put when we tried to have Maureen removed as trustee, she stayed that pending on what was going to happen up here. So I would say from a practical standpoint, the order didn't do us anything, but from a legal standpoint, what we're doing here today is very important for us. And that's why we request that that order be affirmed. And that is all I have.
Thank you.
Any questions? Thank you.
Dr. Dwyer, you have about 5 minutes left.
Thank you. I just would like to say that Magistrate Stargill did speak in my defense when the issue about trustee and that came up and other issues because my siblings keep bringing me back into court. She did say, because of the numerous settlements, you did not, she agreed with me that I did not have a chance to defend myself. For example, saying that I acted in a hostile, angry, what's that other word? 3 adjectives. That's not my personality. You can't be a nurse. You can't take care of your aging parents. You can't be that type of person. You just can't. You can't get along with people by acting like that. I've never acted that way. And so I don't know where that came from. I think that I never had a chance. There was never any examples given of such behavior. And that would be frightening for Jimmy anyway. He has Down syndrome. And then the other thing was the standard that he keeps saying. What was that?
Abuse of discretion.
Yeah. I don't know where that's coming in because,
Well, that's part of the legal standard by which we review certain actions by the trial court. We have to determine whether or not the trial court abused its discretion.
well, I guess I refer to them in my brief as saying that I thought the magistrate overreached her jurisdictional bounds by removing me as trustee when my parents have every legal right to do that.
I guess what Mr. Fogel said was that you haven't been removed as trustee. That action is pending before the probate court.
And she said it's depending on what happens in here today, if I understood it right.
At this point, we can only look at what's already happened. We
Right.
can't look at what happened after the judgment. So we can't base our decision on what might happen in the future.
Okay, so she did remove me as trustee of the Community Fund Management Foundation. I should clarify, the bank and community fund are the trustees. I am the designated advocate, and she removed me as that and put Suzanne in that. And that's the position that Mom put me in 2003, 13 years before they died, and did not name any successors on any of the other siblings on that. And I'm contesting that it should be reinstated and that on Jimmy's accounts, he was in a joint account with my parents, and I was paid on death. And so I'm to take care of Jimmy's accounts, and anytime the Social Security went over a certain amount, because the role of the trustee in the special needs trust, she wants to remove me as that to the magistrate. And the role of the trustee and special needs trust is to protect Jimmy's funds so that he doesn't lose his Medicaid and disability benefits. So if he exceeds $2,000, I have to make sure it goes right up to community fund. And I did that. And they're saying that I didn't give him his money when I did. I paid for the Disney World and all of that, and the treadmill, all of that I put in the brief. I'm not going to waste time with that now. So I don't see where I have abused in any way, shape, or form my role as the designated advocate. And I don't understand all of those attorney fees, and it was my first time going to court without a lawyer. And I did not know I could stay. I didn't know that that I had a chance to not have to pay all of those fees, because again, they were for the trial, not with the settlement issues. And they broke the settlement numerous times. I have lots of emails to document my efforts to make communication with them. And they did not respond to me. They didn't let me take Jimmy to family therapy. That was all in the settlement. I never brought that against them. And I couldn't defend myself in court because when I opened my mouth, their lawyer said, "You haven't been asked a question, no talking." And so I couldn't defend myself to show where they also broke the settlement, but I was trying to work together with Suzanne to come to a way that we could work together as co-guardian. And I hadn't brought them to court sooner, and she did it within 3 months. So and then Mr. Fagel came on, so he had never seen or heard all of that happened in court. Thank you.
Thank you. Your case has now been submitted, and we will issue a timely decision. Thank you. Dr. Ho, whenever you're ready, you can get started. Would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
Okay, thank you.
Good morning, Your Honors. May I please the court? I'm Dr. Chachi Ho for appellate. First, I want to thank Your Honors for giving me this opportunity to talk in front of you. And it breaks my heart to hear the previous case. Similarly, maybe Judge Kinsley and Judge Bergeron can recall that my divorce cost almost $500,000. And the guardian ad litem fee that's being approved, $150,000, have resulted in my jail sentence that Mr. Evans filed for 60 days in jail. And currently, I'm still facing 10 days in jail on July 22nd, because after the appeal of C-2200319, the trial court has ordered additional $20,000, $30,000 of GL fees, and additional $50,000 to my ex. So I'm here, but different from the previous case, I actually have a great job. I have a wonderful job I love. Unfortunately, I'm facing losing the job because if I go to jail. Also, I have the privilege understanding there's a chance for motion to stay, but I'm not as good as law as Mr. Evans, who caused me to be labeled vexatious. So I could not request the court for stay. But as this court, or at least Judge Kinsley and Judge Bergeron is aware, this case is appeal of two different orders that post-date the court's prior decision in C-2200319. One is for Mr. Evans charging the cost for the appeal of over $16,000, which is exactly what this court said he should not be doing. Second is about 4 hours of his time he charges for talking to his lawyer without providing a bill or explanation or anything to the court. And upon the opinion of this court after C-2200319, Judge Searcy had recused herself. And there's a new judge, John Sonderman, comes into the hearing. And after this one hearing in which the transcript has been provided for your review, Judge granted something outside the mandate of the remanded appeal court from the C-2200319. Instead, she granted something opposite. Because in the appeals court opinion, Judge Kinsley has stated, a motion filed before this court to which guardian ad litem did not respond suggests he may be billing the parties for his work on this appeal, meaning the total amount will exceed $150,000. While not pending before us, any motion for the payment of GAL fees for this appeal would be of dubious merit. And this is exactly what the trial court granted. Judge Kinsley further...
And was there any record of what the fees were for? Were there any invoices or anything like that that were submitted?
Thank you, Your Honor. There was no invoices. We did not even get a motion. Guardian did not even file a motion. Instead, he filed a motion for $3,000, which included $1,400 for his 4-hour talking to his lawyer. And he did attach a bill of $2,500 for his lawyer's fee. It's not his time, it's his lawyer's time. So he filed a motion for his time of $1,400 without a bill, just 4 hours, and his lawyer's bill. And we went to court. Nobody knows we're talking about $16,000. He never filed a motion, never let us know he's intending to charge for the appeals court charges. And he is fully aware of the appeals court opinion that he should not be charging these fees. But he deliberately not charging, not submit a motion because he knows that will be against opinion. Instead, he actually drafted the court order and handed to the judge at the hearing into a thick packet, if you can look at the transcript. That is ex parte communication. He never provided to me or my appellee, and we have no idea. This is just a violation of due process, and this is strictly prohibited by the law, the Supreme Court. So I want to cite some cases, probably in my brief I already cited that, because that is a main issue in which numerous cases have clearly said when there's no hearing, no motion, no opportunity to be heard, violated the broke due process, and the order is void and must be vacated. For example, in State ex rel bail, or in regarding guardianship and jurisdic, I probably read it wrong. And Armstrong versus Menzel that I have cited, it says these kind of behaviors are unconstitutional and fee judgment is void. In regarding guardianship or wall fee, the fee order affected substantial right without notice or opportunity to be heard. So I see this as the plain error of the court, simply a huge violation and due process. And
There was a hearing though, correct?
There was a hearing that was held for that $4,000. So Mr. Evans submit a motion for $4,000 for the hearing for $4,000. But he, at the same time, submit a court order for $16,000 without our knowledge. This is how I find out. In addition to that motion for the $4,000. And the judge literally did not know what court order Mr. Evans drafted. And she thought Mr. Evans drafted a order in which it's about that $4,000 fees. So she signed that $16,000 order on the same day, October 16. And Mr. Evans noticed the error, and after a month, that judge didn't grant that $1,400 plus $2,500 of attorney fees. Undauntedly, he emailed the judge, he emailed all of us, that's not ex parte, he emailed all of us and said, Judge, that was wrong, you should grant me that $3,000. So judge, after his motion again, which is pretty much a repetition of that a month ago, granted $1,400 and rejected that $2,500 of his lawyer fees. So there's just numerous errors occurring. First, there shouldn't be ex parte communication. There was no motion filed for that $16,000. There was no hearing for that $16,000. You have the transcript in front of you.
Dr. Ho, at the October hearing, didn't you ask to question Mr. Evans about the basis for the attorney's fees? And had you been permitted to do that, would that have elucidated what the $16,000 was for?
Indeed, in that case, that would be the reason I want to ask that question, because I was shocked. What's a discussion? I was shocked not because of that $16,000, because I didn't even know that $16,000 was being requested. I was shocked that Mr. Evans lied to the court that this fee that he's talking about is that $4,000 has been approved by this Court of Appeals. And I wanted to ask some questions. So I requested, indeed, in the transcript, I asked the judge, may I ask some questions? And the judge answered, no, this fee, which she's thinking about that $4,000, has already been approved by the appeals court because she's new to the case. This is her first hearing. And Mr. Evans told her that. And it's understandable Judge Sonderman had no idea and thought Mr. Evans, the lawyer, which is very credible, said that this fee has been approved by appeals court. So she told me, no, it has been approved by appeals court, which is a lie. And if the judge had allowed me a chance to ask, then this would be all clear out. So there was indeed no chance to question Mr. Evans. As you can see, judge said no. And she said the reason is it has been approved by the first district or court of appeal, which is opposite because the first district told Mr. Evans, your appointment is over and you should not be on the case anymore. But instead, he is doing the opposite. And in such a dubious manner, ex parte lied about that it has been approved and subsequently continued to label me vexatious. But that's beyond the point. But I'm trying to focus on this court have really broken the barrier for people's access based on the previous opinion. Unfortunately, because of a new judge, these mandates are not carried out. Instead, the mandate was carried out in the opposite way. First, no motion was filed. This leads to the plain error. Second, the trial court is granting fees that incurred in the appeals court. The appeals court would be in a better position in determining these fees, which is in Appellant Rule 23 or 24. Trial court have no jurisdiction to grant fees that incurred in appeal. Third is ex parte communication. It's outright documented in this record, and it's just a plain error. Fourth one is, this is against what this court's opinion. Judge Kinsley already stated, even though at that time it's a dissenting opinion, it's violated local rule 10.5, superintendent rule 48.03. It's violate judicial conduct for granting way over the fair market value 2.13. But instead of backing off, undoubtedly, Mr. Evans is charging the fees for the appeal.
Dr. Ho, if you'd like to reserve 5 minutes, your time is up.
Thank you, Your Honor.
Thank you.
May it please the court, Dr. Ho. The first thing I have to say to this court is I did everything I could to not stand up, to not object, but she is making salacious claims against me that are simply not true.
Mr. Evans, I'm going to redirect you for a minute here. Was there a motion filed?
Your Honor, the process in the Domestic Relations Court of Hamilton County is that bills are sent to the parties on a monthly basis. Once you're seeking payment for the bills, there is an order for payment of guardian ad litem fees submitted to the court.
Well, these were your attorney fees, correct?
There are two different pieces to this, Your Honor. Yes, she is mixing things together. Let me back up a step. I think there are two entries that have been issued by the courts that are dispositive to the issues before you today. The first entry is an entry issued on August 9th, 2002 by the trial court. That entry has the statement, "The remaining balance on deposit shall continue to be held by the clerk pending the appeal and additional award of GAL fees." That's number one. More importantly, Dr. Ho filed a motion to remove me in C-22-00319. That entry was specifically denied by this court on October 5th of 2022, when the presiding judge at the time, Judge Myers, wrote, "In this case, the order appointing the guardian ad litem in the trial court was entered on December 2nd, 2020, and provided that the appointment shall remain in effect until discharged by order of the court, by the court filing a final order in the case, or by court rule. In a subsequent order addressing fees, the trial court indicated that the remaining balance would be held by the clerk pending the appeal and any additional fee awards."
Well, but Mr. Evans, I admit I'm not familiar with DR procedures the way that you probably are, but I've not seen in any area of the law an instance where a court would not assess the reasonableness of the fees based on the common benchmarks that all courts use to assess reasonableness of the fees.
They do, Your Honor.
So how did that happen here?
So that happens because when I submit a request for payment of fees, all of the billings that have been sent to the parties are submitted with it. The parties.
Where is it submitted?
Domestic Relations Court.
And
it's
where
attached.
where in the record would I find that?
It would be attached to every order
Because
for
I've
payment
looked.
of guardian ad litem fees.
I've looked in this case, and I've not seen an itemization of fees, hourly rates, all of that stuff. So tell me where in this record I would find the documentation for the $16,000.
Okay, so there are two entries that she has appealed. The one entry, which awards the fees that had been accrued through that point, and a second entry that was on the motion to reimburse my expense in defending a common pleas case that she filed against me.
Understand all that.
Okay, so.
My question is, where in the record would I find the itemization for those fees?
They would have been attached to the order for the payment of the guardian ad litem fees that were submitted on October 16, 2023. Those bills were attached to the order that was submitted for the court to approve. So the court clearly had them and then issued the order of October 16, 2023, separate from the order as to the issue of.
But if they're
the
not
complaint.
attached to the order, then where are they?
I don't know, Your Honor. They were submitted with that order to the court. They were specifically handed to the judge. The parties had already received the billing statements. I can't answer that. I don't know why they're not part of the record. So, as I was saying, Judge,
Okay, I'm going to stop you again. On page 3 of your brief, it appears that you are saying that you should be compensated for the time and work expended on the appeal. So I just want to clarify, the $16,000 that was ordered, $16,900 and whatever, that was for the time.
not all of it, Your Honor. Some of it was ongoing from July 1st of 2021 which is prior to the court issuing its final decree and orders after the custody trial had occurred, to August 28th of 2023. So that is shortly after the initial appeal from this court was released. So there's a mixture there of the time that was spent, and the court was aware that that appeal was ongoing. And the court previously in August was aware that that appeal.
So what you're
going.
saying is this is not just time for the appeal, this is time for other stuff happening at the trial court?
That July 1st, 2021, the case had not been resolved yet. The court had not issued its final orders.
So what about your representation to the trial court that we had decided that these fees were appropriate?
Your Honor, the opinion in 319 upheld my fees.
Your prior fees,
That's
not
correct.
ongoing fees?
That's correct.
So
And then there
did
were
you
motions
represent?
pending with the court.
Did you represent to the trial court that we had approved the going forward fees?
No, Your Honor, I did not.
All right.
I did not. And the court knew that the issue was under appeal because she filed the appeal on this October 16th. She filed the appeal of the November decision, or the second decision, and the court was aware and actually took a further request for fees, and it's been held in abeyance ever since October of 2023. It's not been ruled on by the court. So while she keeps saying there are additional fees that have been awarded, there haven't. The total that I've been paid since this case started is $130,000. The amount that is remaining for the work I have done through August 28th of 2023 from the appellant is $6,780.56, which the court ordered be paid by October 24th of 2023. That was the decision of
Mr. Jones,
October 16th.
Are you aware of any case in Ohio where GAL fees of this magnitude have been approved?
Your Honor, there is very little appellate law on the issue of GAL fees because no one raises that as an error. And obviously, the standard is abuse of discretion. The trial court is in the best decision to decide what should be covered and what shouldn't. And if I'm doing work because I was a guardian ad litem and there is an appeal, I should be paid for that. Just like a guardian representing a child in an ADN case
at
is paid.
some level, the amount of fees here could have presumably paid for the kid's college. At some level, doesn't the court have an obligation, don't you have an obligation to step in and say, this is getting out of hand? Is this in the best interest of the child?
Your Honor, I appreciate your concern. This was created by appellant. This was created by appellant's filing of motion after motion of the 9 appeals that were filed with this court.
Right, and I get that, but does the court not have an obligation to say, I don't need the GAL to run around and respond to 9 different motions that may be meritless?
The only person that can defend those fees are me. No one else can do that. No one else can explain to the court how those fees came about, why those fees came about. We dealt with that in 22-319, and this court upheld the fees.
I understand. I wrote the opinion.
And while I appreciate the concerns that Judge Kinsley has raised, the reality is that this was caused by appellant. Appellant could have paid the fees that were due at the end of the trial, and that would have been the end of it. Appellant didn't have to raise issues over the fees in the appeal. And the reason there's so little appellate law on it is because attorneys representing appellants don't raise those as error, don't raise those as issues. That's why it's an issue. Appellant filed twice with the Disciplinary Council of the Supreme Court of Ohio. Both of those were dismissed. There's a third complaint with the Disciplinary Court of Ohio that was filed, that I was contacted on in October, that for some reason is still pending, even though the trial judge sent them a 5-page letter explaining why my fees were what my fees were, and why those fees were created by the actions of appellant. The history of this case, it is one of the most high-conflict cases I've ever been involved in. It is one of the most difficult cases I've ever been involved in. I am very, very proud of my work with this young man. This young man, when I met him, was in 8th grade, struggling, having multiple issues, as testified to by his guidance counselor.
And
He is now.
we say, and like, I appreciate that, and we see a lot of high conflict. I mean, most of the cases coming up to us are very high conflict. And we can look at them and say, this just doesn't make sense. Why are you all doing this? But ultimately, at the end of the day, I've not seen anything close to this level in terms of GAL fees, notwithstanding high conflict, challenging issues with the kids. Like, it's just.
Because no one has raised that as an issue with the court, Your Honor.
All right.
Because they accept the fact that those are the guardian ad litem fees and they pay them. This is not the only case I've had where the fees have hit this kind of number. And again, to be sure, the only orders through today total $136,000, not $150,000, which keeps getting bantied about. My authority comes from the statute 310904A2, which says the court may on its own or shall appoint a guardian ad litem at the request of either party, and then the entirety of Rule 48. Rule 48 makes it very clear that the guardian ad litem is to be served with everything, notices, pleadings, anything that's going on in the case. That includes appeals. And it doesn't say just while in the trial court. The Rule 48, Rule of Superintendents 48, promulgates how a guardian ad litem is to act. It was different when I was appointed in 2020 than it is now, but the guts of it are very, very similar. And it includes the authority of a court to enforce it through its contempt power. It says that I have to do a whole list of things that are included, but it doesn't limit it to that. This case, like I said, is the most difficult case I've ever been involved in. This child is likely to graduate Turpin High School as a valedictorian. He was elected captain of his tennis team this past
Can we not
week.
give out details of the child?
Pardon?
We want to protect his privacy, so please don't give out details.
I appreciate that, Your Honor. But I am very proud of the work that I did with this young man, and I'm very proud of who he has become. And while I understand that the fees seem exorbitant to some people, in this case, and other GALs would say, with the work that I did, they were not. I am the most experienced guardian ad litem in Southwest Ohio. I've been asked to serve as an expert witness in other guardian ad litem matters, reviewing other guardian ad litem opinions and commenting on them. And I take significant pride in the work I do. I would ask that you look at Rule 48 in its entirety. I would ask that you understand that this is not the normal case that comes through. And I would ask that you uphold my fees for the work that I've done as abuse of discretion. This was not arbitrary. This was not capricious. And this court has already ruled on the issue in that October 2022.
I believe this is a different issue, though. It appears that at least part of what you are asking for is your attorney's fees for the appeal. Is that, am I wrong?
I filed that motion. The only reason I had to pay those fees is because she alleged I committed malpractice.
Can you answer my question?
I'm willing to
that
forego
correct?
that, Your Honor. I'm willing to give that up. I don't
How do
care.
we know how much that is if we don't have the invoices? in the
It's a
record?
separate entry, Your Honor. That was a separate entry issued by the court that granted me $1,400 for my time spent in that matter. I'm willing to waive that. I don't need that. That's fine. I am entitled to the fees I incurred in representing her on the appellate work in all of the filings, even in all of the filings, if you look at 319 that were filed simply under 319. There were 41 motions filed, of which 25 were hers. Thank you, Your Honors.
Thank you. Dr. Ho, you have 5 minutes.
Thank you, Your Honor. I am so delighted. I felt I was heard. First, I have 5 points, kind of just to address the response. But 5, the first point is Where in the record can I find the motion? There is no motion. There is no bill. How does a $4,000 motion end up $16,000? Second, what is that $16,000 for? Mr. Evans just told the court, oh, this is part of the prior charges as well. He referenced this is not just for the appeals. But in fact, all the trial court decisions have been paid in full with great difficulty. And then later in this court, he just stated, oh, this is for my appellate court. I'm going to waive that $1,400, but please grant me that $16,000. So there's a direct contradiction right in his statement right here. Third is Mr. Evans just misrepresented. There's a question whether Mr. Evans told the trial court that this $16,000 was approved by the appeals court. Mr. Evans' answer is no. But if you look at the transcript, TP 29 and 30, Mr. Evans says, I submitted, which is in the thicker packet, and he actually just admitted he handed the trial court judge the thicker packet without filing with the trial court. And he was asking, the court says, well, I did review. You were asking for new fees for the Court of Appeals, did not rule on yet. Mr. Evans answers, that's correct, Your Honor. And the court asks again, so these fees, this order you just handed me, are those the Court of Appeals fees or new fees? Mr. Evans answered, no, this is the order that the Court of Appeals affirmed. So he have repeatedly lied to the trial court, and he just lied to this court, saying he did not say that, but it was in the transcript. The fourth is clearly, without any motion, the court cannot grant fees that directly benefit the guardianship, even if he filed everything processed correctly, even if everything, there was no ex parte, no lies, he filed the motions and bills. This court have great information what the appeal is about.
Dr. Ho, I'm looking right now at the October 16th, 2023 order that orders payment of the $16,000. It looks like it's in chunks, so there's like about $3,500 to be released from a previous deposit, and then $6,700 ordered to be a new deposit by you, and $6,700 ordered to be a new deposit by your ex-spouse.
Yes, Your Honor.
And I'm assuming, I'm not great at math, especially not quick math, but I'm assuming that adds up to about the $16,000.
Exactly.
I don't
Yes, Your Honor.
see anything on here that makes a finding of reasonableness. Was there ever any reasonableness determination by the trial court that this amount was reasonable?
Your Honor, there was no any finding or even a chance. I was trying to question the trial court judge, but I was shut down. The trial court was being masked by a lie that this court has appealed. Court of Appeal have approved that $4,000 fees and mistakenly signed that $16,000. So there's errors after errors. Not only there was no reasonableness, there was simply no motion. Without the motion, there won't be any discussion of it at all. And that is indeed the challenge of this problem. And the Supreme Court clearly stated that they should not approve fees that beyond the fair value of the service render, and that's Ohio Code of Judicial Conduct, R2.13C. And in addition, even if they were fair, even there was fair value, the court does not grant fee that does not benefit the guardianship. For example, in regarding guardianship Ellen, in regarding guardianship Noah, fees that not legal guardian work are regularly denied. In this case, as previous opinion have pointed out, and currently you heard me, that these fees are not only not benefit the child, but also drain the child's college fund. This is not a high conflict case. We have equal jobs. We have one son who have told the guardian the first day he met the guardian, he wanted to spend 50% time with mom, 50% time with dad. And that's what the guardian did after the first day we met. We signed a shared parenting plan after a month. Guardian should be discharged at that time of $15,000 fees. But instead, he's the source of conflict. And after that, challenging the guardian of the fees has been the main source of conflict. We are not arguing about custody. We have no problem with child. Our child is so blessed, and we are so thankful, not for Mr. Evans, but just for this unknown power that lead us all through. But during this,
Dr. Ho, your time is up.
thank you, Your Honors.
Okay, this case has been submitted. We will issue a timely decision. Our court is concluded for the day. Thank you for coming, and thank you to our visitors for coming and observing today. And we